distinguished guests, ladies and gentlemen, we can move ahead to the first session today, which is Global Corporate Governance Developments, Relevance to the Region. We have a very good panel here, people who've been very closely associated, not just with examining the crisis, but also examining ways to improve corporate governance in the world. We have Mr. Douglas Hansen-Luke, CEO of Rebecco, Middle East. We have Mr. Dr. Metsanis, who I know very well from the OECD Corporate Governance Committee. We have Joe Tortorici, who I know very well also, and Dr. Stephen Davis from the Milstein Center at Yale University. So what we'll do is I'll give 10 minutes to each of our speakers to go through what they think are the biggest areas of experience, and also, if we can, just if you like, speculate what are the importance of these issues for the region. There'll be 10 minutes each, and then I want to pass. Then there'll be some discussions between us, and then I want to pass to the floor straight away for questions from the floor. So I'll go through in the order that's in your program. If I could start off with Mr. Hansen-Luke, please.
Your Excellency, Dr. Saidi, Dr. Kirkpatrick, ladies and gentlemen. First of all, I'd like to say thank you very much to Hawkamah for organizing this, their fifth event. It's immensely important to this region. Today I'd like to talk about the responsibility of ownership, about active ownership. I sit here today representing the asset management industry, and I'd like to talk to you about how we view that responsibility, the principles of it, how that actually works out in practice, and then also some of the risks associated with that, before concluding with I guess, a conclusion that it's not all easy. Starting off with the issue of responsibility. If we actually look at the recent financial crisis, going back a year and a half, 2 years, 2.5 years, who would you say is actually responsible for the crisis? Is it the subprime industry? Is it banks? Is it bankers? Is it regulators? And the answer to that can be yes to each of those individual groups. But I'd also argue that the people that bear some of the prime responsibility are the people that used the services that eventually blew up, and also the people that invested in the companies that were doing that, the owners. So who's responsible? Well, if you own something, then you're responsible for it. If you're a shareholder in a bank, if you're a shareholder in a property company, a mortgage finance company, you can't walk away from that and then blame the industry, blame management, blame regulators or the bankers. You also have to bear some of that responsibility yourself. So when looking at responsibility, what are the principles that we use? I think we start off with the International Corporate Governance Network and the principles that they have here. And the very first principle they have is that actually the first principle of corporate governance is making long-term profit. So I want to challenge anyone who thinks that there's a conflict between corporate governance and responsibility and actually making money. There isn't. The second criteria is to consider all stakeholders, not simply because it's the right thing to do, although I believe it is, but also because if you don't look at all of the stakeholders, then you're also not going to look at the risks, the potential harm that can come to your company. And we've seen a lot of that recently in companies. I think suddenly the banks realize that they've got a lot more stakeholders than just their shareholders. Also, of course, you've got to have aligned responsibilities and aligned incentives. So it's an important part of corporate governance, which I'll come back to. It's an important principle for us. And again, the ninth principle of the ICGN is actually that shareholders must take ownership, that they must be active. Now, how does that principle of active ownership actually translate into reality? Well, here we use the UN, we at Rebecca, and we're not alone. There are now over 800 signatories to the United Nations Principles of Responsible Investing. At the last count, around $22 trillion worth of institutional money globally is said to be associated with this. Now, with those UN Principles of Responsibility, which we were one of the early subscribers to, and which this year we've actually made a core part of our investment process across the board, so that by the end of 2011 we'll have fully incorporated those principles. How do you actually manage them and put them into practice if you want to be a responsible owner? Well, one part of that is taking account of risk-adjusted returns and risks, externalities, which is why when Dr. Saidi was talking earlier about ESG, I was nodding my head vigorously. And it's environmental, social, corporate governance issues are incredibly important. When you're analyzing a company, when we analyze a company before bidding and buying for it, you have to take into account not just a P&L, not just a balance sheet, but you also have to look at the risks associated with that. It's easy now, after the event, to talk about the environmental risk with BP, but actually, if you look at the corporate governance risks that we as owners were all running in the beginnings of the financial crisis, it's clear that we as owners were not looking at corporate governance risk. A number of the banks that we owned, a number of the property companies that we owned are now worth far less than they were before. So it's ridiculous to say that you shouldn't look at these external risks. So that's a very important part of that for us. Another part of the, if you like, incorporation of ESG is to say what happens when you're not happy with a company. Do you simply sell and walk away, or do you actually try to engage with the company? Now, I think there are really only two times when you can influence people. One is when you're about to say that you're going to give them money, and the other is when you're an owner. If you actually say, we're not happy with what you're doing, we're going to sell and walk away, you no longer have any influence. So it's our strategy and the strategy of many of the people in the investment industry to actually work and engage with management and to highlight to them what we think could be the risks. And of course, one area where this is particularly important is the way that incentive structures are set up. At the bottom level, the medium level, the executive management level, and also at the board level. It's very important to make sure that those incentives are fully aligned. A couple of examples that I would use for that as to perhaps how the world is changing is to look at AkzoNobel, one of the largest paint and coatings companies in the world. They've actually said that none of their executive board members are able to get 100% bonuses or to reach their maximum bonus potential unless they're actually in the top 3 of the Dow Jones Sustainable Indices when they're ranked as a company. This is actually saying we're going to pay people to ensure that they're looking at external factors and sustainable factors as well as the next quarterly profits. Other companies that are well known that have done this include TNT, the global logistics company. They're not being as strict in terms of putting it with a particular index or benchmark, but they are saying that they will be considering energy usage, they will be considering motivation, they'll be considering alignment of interests when they pay people. These are all important parts of things that can be done. But of course, although it's easy to say, well, we will follow the ICGN principles, we will use the UMPI to set about how we actually implement that in practice, there are still a lot of risks that remain. I think one of the risks is relying on other people. So if I look at the 3 key risks that I would like to highlight from our perspective at the conference today, one of those risks is actually regulation. Augusto de la Toro from the World Bank, the Latin American economist for the World Bank, and INS put together a very good study on regulation. Now, there are 3 types of regulation. There's principal agent, there's regulation of externalities, and there's regulation of kind of bubbles or asset bubbles, mood regulation, the fact that people don't always act rationally or have bounded rationality. The regulation that you put in place for each of those is actually slightly contradictory. If you have a lender of last resort, then suddenly you're encouraging moral hazard. So regulation in itself, regardless of how it's implemented, and there are lots of failings and difficulties with that, but regulation in its own right will make a big difference, but it cannot be something where you can pass the buck to the regulators. Another part of that is incorrect incentives. For bankers, particularly for bankers, but for many others, if the incentives you get are all related to what you do in that particular year, and you get paid your bonus in that particular year, then of course, if it all goes wrong 3 years later, it's not often that you see a banker giving back their money. think we tried that with Royal Bank of Scotland and Britain. It didn't happen. So it's very important that incentives are not only correctly aligned and explained, but they're paid over a multi-year period. So you don't have an asymmetric situation where you can gamble, take lots of risk and get a big payout, but you don't also suffer if it goes wrong. And then finally, there's what I'd call corruption and transparency. I think Dr. Saidi put it better when he talked about it as, or maybe you did, as related interests and conflicts of interest. Now, Transparency International came out with their latest report this week. In the area in which we operate, the Middle East, North Africa, Central Asia, there are 15 countries that score less than half marks on transparency and on corruption. Now, that's something that we've really got to work on as a region. Within this region, there are 2 signatories to the UN PRI out of 800. Now, I would really like, if we can work together at the end of this day and a half, that we can say, well, transparency is going to improve, that we have solutions for corruption, that 15 goes down, and the 2 signatories that are here in this region actually goes up in number, that we find a sovereign wealth fund, we find some of the leading investors, and they are expert leading investors in our region, to actually subscribe to these principles and to fully endorse them here. And then finally, if we were to bring all of this together and to conclude from our perspective, it is that corporate governance is a commercial proposition. It makes money. It's good at the same time, but it also makes money. And there is nothing sustainable, there's nothing good about companies or factories that are bust or close down and people who lose their jobs. There's nothing sustainable or good about destroying huge amounts of value. So we think it's important that you always link the commercial side to this. Corporate governance makes money. We also highlight, as I hope I've done with the risks, that we don't believe there is one silver bullet that will fix corporate governance. It's not a box-ticking exercise. For us, this is something which we believe is a long-term process, but it's a long-term process that will benefit and enrich both socially but also financially all of us if we push through with it. Thank you very much.
Thank you, and thank you for staying in the time limit. I'll try and be a tough chair. Just a quick question for you. You're a member of the ICGN, so you've signed all their statements. Presumably you also have signed to the UK new Stewardship Code. And then I think a quick question for you. How important will be these investors in the region who've looked closely at things like the ICGN principles, the Stewardship Code? Will they be more important to the region in the future? Will they be more of a challenge?
I think it's incredibly important that we actually do have people in the region signing up to these, and people have, but it will be important. I mean, for 2 reasons, really. One is it will slow down the rate of capital that comes into this region, and despite the oil wealth, there is still a huge demand for capital and a huge need for capital to build out the infrastructure and to fulfill the plans that people have for the region. And the second point is that it needs to happen, it has happened. Actually, the UAE, when I was talking about Transparency International, they're one of the highest or best scoring countries in the Gulf. I don't think that would have been the case a little while ago, but Dubai was hit hardest by the crisis. They've really seen what conflicts of interest, what bad corporate governance can do, and they're making a very clear statement now that actually it will be better. And what does that mean in practice? It means that people will lose less money. There will be less risk.
As you say, the business case is absolutely crucial to get across to companies, and particularly to families who often regard the company as theirs and theirs alone. If I could turn to Dr. Metsanis. Thank you for 10 minutes.
Thank you, Grant. Your Excellencies, ladies and gentlemen, good day. Thank you for the invitation to be here. Since I am a regulator, I try to approach the issue from a policy perspective and try to present to you some basic ideas on my view as to how to proceed. I think most of the important elements have already been tackled by the introductory remarks by Mr. Saidi and Mr. Kirkpatrick, so I will try to pinpoint some broad areas here. I think that corporate governance improvement in the region should take into consideration three important factors. The first factor is the crisis and the repercussions of this crisis for financial sector policies and in all countries. The second factor is the classification of the countries of the region in the broad class of emerging markets. And I think the third factor that needs to be taken into consideration has to do with the Sharia practices which are embedded, which are inherent in the social structures and the social cultures of the region. I start with the first. The repercussions of the crisis have been threefold. First of all, insolvency. Second, illiquidity. And third, deleveraging. Insolvency has been mostly the result of securitization of low-grade assets, which eventually led to problems, and that eventually led to countries, governments to adopt extension of deposit insurance schemes as well as recapitalization policies to save banks. Illiquidity has been largely the result of market gridlock, which in turn is caused by the mismatch facing all banks between borrowing short and lending long, which eventually led to big problems in the interbank market, and this led again central banks to intervene and engage in open market operations, including the European Central Bank as well. And the third one was deleveraging. Banks, financial institutions in general were forced into deleveraging, and this has a serious result on the real economy, leading to problems of financing of real activity. Now, I refer to banks because banks are very special in this respect. Banks are not like other corporations. Banks take on leverage, act as intermediaries, lend to corporations, so whatever happens to banks, both in terms of governance as well as in terms of efficiency, is being transmitted to the rest of the economy. Now, it's very important to understand that the work we have done in the OECD has produced a number of conclusions which were laid down by Mr. Kirkpatrick in his introductory remarks. I would like to point only 2-3 of them which are very important. The first has to do with the competence of directors. It has proved to be an immensely important issue. Directors in corporations, most notably in banks, have to be capable of understanding risks. And risks today are very diverse, and they are very sophisticated. And to the extent that banks get involved in the interbank market for lending and borrowing, then they cannot be isolated from that, and therefore all these risks have to be properly accounted for. Fiduciary duties of directors and responsibilities are extremely important in this respect. They have to be established by law. Company law or perhaps some aspects of security law have to be properly amended. Now, risk management is extremely important. I will give you only one example of that. You all have heard of the troubles that Greece has gone recently. Greek banks did not have any problem with buying toxic products. They had not purchased any of those. So, as a result of the crisis itself, we are well protected. However, Greek banks have bought a lot of government bonds, government securities, which themselves were somehow toxic. And, of course, a good risk management in a Greek bank should have taken care of all these purchases, as well as paying close attention to international credit ratings and all these ratings that they were produced, and he should have taken these considerations properly. They haven't done it. So Greek banks have to suffer because of buying government toxic products, And of course, thanks to the European Central Bank open market operations, we have managed to find ourselves in a path of solvency. Now, another important thing is institutional investors. However, experience, even in my country, has shown that it's very difficult for them to be energized enough to contribute into improving governance practices. This has happened, but only once company law provisions and security laws have been providing the incentives for them to do so. Without incentives, international investors particularly do not find themselves in a position or in a mood to be more active. Now, coming to the second important factor, which is the emerging market status of the region. I think here, from a practical policy perspective, 2-3 issues stand out as very important. Related party transactions is the first. Related party transactions, as Mr. Saidi has touched upon it also indirectly, is a very important element for safeguarding credibility. Disclosure and, if necessary, approval by the general meeting should be a way to go. And the second is insider dealing and insider trading. This is a very important element and a very important problem with emerging markets as far as the credibility of markets and corporate governance is concerned. And the third is disclosure practices and standards, which I'm sure you all know and you have heard of that. And finally, the third factor has to do with Sharia practices. I think that there has to be in the region a proper institutional establishment that will lead to an alignment of faith-based and profit-based approaches, because banks have to take account of reputational risks both against their shareholders, who may be foreign, may be international, as well as their own domestic clients, which are driven by different cultural elements. I think some smart ideas, such as for establishing some special boards within banks that try to align these kind of interests and try to establish standards proper in this respect will be the obvious way to go. I stop here and thank you.
Thank you. If I could just take up one thing you mentioned that I think Dr. Saidi had also mentioned, that is insolvency. Now, Greece is in the list of OECD countries is much closer to the region in terms of the time, the costs of insolvency procedures. How big a problem do you think that is in Greece, and and the type of things you'd like to consider to improve the situation there?
Well, indeed, in the past, we never had the problem of facing bank insolvency. Recently, the government has taken on an initiative to improve insolvency law. However, we're still in the process of a debate, because we're expecting to see what exactly the European Union is going to do overall. What has been a very important element in this respect has been the role of European Central Bank in using Greek government bonds as collateral for domestic banks to get refinancing as a return of that. Now, as far as other corporations are concerned, insolvency law worked pretty well. However, this particular aspect of bank recapitalization has been a new issue for us, and we're working towards some sort of a resolution. But as I said, that's a debatable issue and still has not taken any clear direction.
Mm-hmm. Good. Thank you. If I could turn to the third speaker, Joe Tortorici, please.
Before we turn to the slides which I've prepared, I'd like to make a few general observations. The topic of our panel this morning is global corporate governance developments and their relevance to the MENA region. What we have seen during the global financial crisis of the past 2.5 years or so is, in my opinion, due in large part to a failure to apply principles of good corporate governance virtually globally, and at a whole host of levels. As examples of this, boards, quite frankly, in many cases, thank you, Stephen, became tone deaf towards the voices of their shareholders. They also cumulatively, in the U.S. financial services industry, did a very poor job in overseeing their companies' risk profiles. Risk managers, to compound this failure, simply did not seem to understand the activities and businesses that their companies were engaged in. And to compound this further, compensation committees at times seem to simply ignore the wishes of their shareholders in respect of the very important issue of executive compensation. In light of all this, the question could be legitimately asked in the case of many of these troubled public companies, particularly those in the U.S. financial services sector, is, did they exist for the benefit of their shareholders, as public companies should, or did they exist primarily for the benefit of the people who happen to work there? Interestingly, this almost wholesale failure in corporate governance was most prevalent not in the emerging markets, such as we have here in the MENA region, but rather arguably in the most developed capital markets in the global financial system, those in the US, the UK, and to a lesser extent in continental Europe. However, as a result of these failures in the developed markets, specifically those in the United States, it's in these markets where today we are seeing the most significant developments in global corporate governance. More specifically, these developments are and will be provided in the United States pursuant to the Dodd-Frank Wall Street Reform and Consumer Protection Act, which was just enacted in the U.S. this past July. And while Dodd-Frank is U.S. specific, it does have certain provisions which have extraterritorial jurisdiction and, more importantly, will certainly be viewed as a benchmark in terms of corporate governance in the global capital markets, including here in the MENA region, as it develops and is implemented. If one believes in global capital markets, as I do, then one tends to believe that capital, globally, will generally flow towards those markets which are most transparent, most open, and involve the lowest degree of risk. That is, I believe, where governance is best. And while I do not believe that the capital markets in the MENA region partook in the excesses of those in the developed capital markets, I also believe that the MENA region is no different than the global capital markets in this important respect. Let's turn now to the slides which I've prepared. We can talk through them. These slides are very specific, and we'll make these available to any of you afterwards through Hawkamah that would like to see them. What I don't intend to do is read these slides to you, but I'd like to highlight some of the more important points which I think have relevance here to the MENA region. As I said earlier, the Dodd-Frank Act was enacted this past July in the United States. It's a series of laws and regulations which will be rolled out over the coming months and years, Grant, as I think you well know. But its centerpiece, what it's really intended to do, is to try to contain systemic financial risk in the U.S. and as a result have a knock-on effect into the international markets. It is intended specifically to restructure the financial services sector in the U.S. But lawyers in the U.S., of which I am one, are expecting that it will have a knock-on effect into the non-financial service sector companies. And again, while it is U.S. specific, it certainly has extraterritorial jurisdiction involved, and we do feel that it will affect assets and financial services companies outside of the U.S. as well. Next slide, please. If you look at the bottom here, I'd just like to read to you some of the key governance and disclosure provisions of Dodd-Frank as currently drafted. It grants express authority for the SEC to adopt proxy access rules. It provides for mandates for shareholder advisory votes on executive compensation. It provides further limits on discretionary voting by brokers. It provides new pay versus performance and pay versus equity disclosures. It provides for heightened independence requirements for compensation committees and their advisors. It has required clawback policies that reach beyond the current Sarbanes-Oxley Act. It provides for new disclosures of corporate policies on hedging by directors and employees. It contains incentives and protections for corporate whistleblowers. And finally, it provides the authority for the SEC to adopt rules increasing the transparency of securities ownership. Next slide. Some of these are very, very relevant and very important and, quite frankly, groundbreaking in the U.S. One that I'd like to highlight here is the mandate for shareholder advisory votes on executive compensation. As I had said earlier, it seemed during the financial crisis that companies had gotten away from listening to their shareholders on the issue of executive compensation. Here, Dodd-Frank applies in the coming year and at least once every 3 years thereafter that there will have to be non-binding votes on executive compensation. While these votes will be non-binding, query whether any board will have the temerity to ignore a shareholder vote on what executive compensation will be. They will have new pay versus performance and pay equity disclosures. Pay will no longer occur in a vacuum, and I think that executives, to the extent that their compensation is held out quite clearly and openly to shareholders, will tend to shy away from some of the executives that, some of the excesses that we saw during the financial crisis. And there'll be heightened independence requirements for compensation committees and their advisors. Quite frankly, during the financial crisis, some of these committees almost seemed to be rubber stamps of the executives that they were compensating. Turning to the next slide, we'll see required clawback policies that reach beyond Sarbanes-Oxley. These clawback policies will go directly to the numbers that are reported by these corporates and will have a look-back period of 3 years, which apply to both current executives and executives who have left the company. A lot of the problems we saw had to do with numbers not being properly accounted for. And I do think that having a clawback provision in effect will really tend to focus, again, executives on the numbers that they're putting out there, which are the basis for their compensation. You'll also have new corporate policies on disclosing hedging by directors and employees. Quite frankly, in the past, some of these companies had directors who were hedging their own equity and thus not aligning their interests as executive directors with those of the shareholders of the company. Next slide. To move a little bit quickly, again, as I said earlier, the Dodd-Frank Act will primarily be a U.S. piece of legislation, but it will have extraterritorial jurisdiction. What I think most important, however, is that it will provide a benchmark in governance going forward. What we're talking about here today is the globality of capital markets. And I don't think that developments in corporate governance in the U.S. will be ignored here in the international financial capital markets and in the MENA region. Next slide. Again, the first bullet point, emerging markets do look to U.S. standards when formulating their own corporate governance standards. And it's likely that the Dodd-Frank reforms will form part of this analysis going forward. We will make these slides available to any of you who would like them after today. Skipping ahead, go ahead, Nick, to the next slide, because this really touches it. What we saw in the U.S. is that the enactment of Dodd-Frank was necessary to monitor and regulate financial systemic risk in the U.S. However, the impact of Dodd-Frank will be felt well beyond the financial sector, and its proponents hope it will give shareholders a greater voice in corporate financial governance. Financial markets around the world are so interconnected these days that the changes made in the U.S. are bound to affect users of all financial markets, not just those who are active in the U.S. markets itself. Key effect of this is that to attract international long-term investors, Gulf companies and those here in the broader MENA region will need to have good corporate governance processes in place. Again, this goes back to my point of benchmarking. And finally, as a last point on general observations, I would just like to touch a little bit upon the notion of the regulator. Dodd-Frank is a set of rules. However, good corporate governance cannot be put in place without firm and effective regulation. What we talk about in the U.S. these days is enforcement, enforcement, enforcement. This applies here in the MENA region to the same extent as it applies in the U.S. A set of rules is fine in and of itself, but in order for them to be implemented, you have to have effective and comprehensive regulation. I think we're going to see this in the U.S. going forward, and I think we'll have more of this in the MENA region as a result thereof. Thank you very much.
Thank you very much. I think it's very important to point out just how many corporate governance implications the Dodd-Frank Act has. They're quite far-ranging. But in the region, one has to do with dominant shareholders who regard the company as theirs. In the United States, it seems to be CEOs and directors who regard it as theirs. And so they've now gone to the court challenging the SEC, challenging the Act, actually, and the SEC, and coming up with more liberal proxy solicitation materials. Could you say something about why there's such a reaction in the United States?
I think there was a great misalignment of interest in the U.S., Grant, and I think politics plays a role in this. I think that there's going to be a great attack on Dodd-Frank following the elections in the U.S. This week. I think that there's a great division in the U.S. among Democrats and Republicans. I think that there are different interests within the corporates themselves lining up with different political parties, strangely to say, as a lawyer. But I think time will tell on this point. I really do think that time will tell. I won't make a prediction as to how it's going to go.
It's just recently sitting with some U.S. directors, I was surprised how they thought the end of the world was approaching, and thought this was a cataclysmic act. If I could turn now to the last of the speakers, Dr. Stephen Davis from Yale. Please, Stephen.
Is that your fun? Thank you, Grant. And I also want to pay my respects to the OECD and Hawkamah. I had the pleasure of coming to the first Hawkamah meeting 3 years ago in the UAE, and it's extraordinary to see how the organization has progressed. And also I want to pay respects to the Capital Markets Authority of Oman, which has shown great prudence and foresight in entering into this process of corporate governance. I think in the United States we have a blue ribbon commission that is going to be talking about their conclusions about the causes of the crisis. And that blue ribbon commission is due to report in December. Now, unfortunately, politicians being politicians, they've decided to already come out with the cures for the crisis before we actually know the causes. So the cures, as Joe just talked about, involve the Dodd-Frank bill. But we don't know the causes yet. The official report will be out on that in a couple of months. My guess is it actually will point to corporate governance as one of the real causes of the crisis. But for now, this is speculation. Meanwhile, the Dodd-Frank bill has set out a series of very important corporate governance reforms. And I think what we need to do is, Joe has already given us some specifics about it, but I think it's important to just point out that this is important even though the corporate governance characteristics of the GCC states are so different from the corporate governance characteristics of the United States. And yet, we have seen that laws such as the Sarbanes-Oxley Act following the Enron collapse have had a large knock-on effect in country after country. And so I think we can expect, if we look carefully at the reforms that have already taken place, that markets across the world will see reverberations from these acts. And I would say that it's not just in the United States that there are efforts to reform corporate governance. The United States was the epicenter of the crisis, but so was the UK. The UK expects to produce its own reforms in about 9 months, but meanwhile, the business secretary, Vince Cable, just recently put out some very interesting corporate governance questions that show where the UK may be heading in this area. So let me just briefly sketch out the conclusions that have been arrived at, the consensus views about how corporate governance failed. And it's clear that it failed in 2 areas. Many of the assumptions that you heard for years, people going around the world and saying, these are important characteristics of corporate governance, those assumptions failed in the crisis. One of the chief failures was that investors, who we thought would act in their best interests, in acting as real owners of equity, whether they be block holders, families in control, or whether they were institutional investors, they did not play the role that we expected them to play. In fact, they didn't walk away with profits. They actually lost lots and lots of money because they stayed too long in companies and did insufficient analysis of the corporate governance risks in the corporations in which they invested. And the second big consensus is that corporate boards failed. And we thought for years that actually the best approach to corporate governance is to have independent directors running companies, overseeing management, and that independence was critical to performance. In fact, it looks like some of the early studies that we are seeing coming out show that the companies, particularly in the financial institutions, with very wide independence on their boards, those were the ones that tended to fail more than others, where there were more insiders or more expert directors involved. So some of the assumptions that we had, that independent boards were good and that they would oversee risk in an appropriate way, that turned out not to be the case. So let me then turn to how the legislation, how the reforms are shaping up. Joe's given us a lot of the details, so I'm going to just step back and look at some of the big picture issues. And one of them is that if you look at Dodd-Frank, and if you look at the UK Stewardship Code, which Dr. Saidi mentioned earlier, there's no doubt that the United States and the United Kingdom are placing enormous bets on the ability of institutional investors to police markets. Both the Stewardship Code and the Dodd-Frank Bill recognize that in the past, investors failed to act as those kinds of owners, but now they are either given more rights, which is the case in Dodd-Frank, or they're being pressed through other means, the Stewardship Code in Britain, to play that role as real owners. So, for example, they now have more rights, as Joe indicated, to review executive pay, remuneration. They have more rights to approve and compose boards of directors. and we're seeing how investors are going to respond to that. And by the way, it's not just in the US and the UK. Australia, for instance, has put government money into something called a Responsible Investor Academy, trying to train investors to be that kind of an owner that will help police markets. And again, it's not just those countries. France recently made an effort to really push funds within France to play a much greater role in applying risk factors, environmental risks, governance risks, and social risks when they're investing. So there's this big picture approach on the part of governments to make investors really act like owners. The second big picture change that we are seeing is this focus on boards. And I think there's a recognition that the effort to look really at independence has gone way too far. That what we need to do is to work on competence of boards. They should have independent judgment. Directors should have independent judgment. But they need to focus on, do they know the business? Are they competent directors? Do they work well together? And also, do they understand not just the business, but the consumers and the stakeholders that companies are involved with? And then finally, do they really understand how to work and oversee risk factors? Douglas mentioned the ICGN, the International Corporate Governance Network. ICGN just recently put out a series of recommendations on how boards can oversee risk. So we're seeing lots of new focus on that, with the big factor being, how can boards have dialogues with owners so that there is a sense of accountability. And we see that through the Dodd-Frank bill, and we see that through the Securities and Exchange Commission in the United States, which has put new regulations on disclosure, that boards have to disclose a lot more about, for example, who the directors are and why are they there. So we're seeing a lot more focus on that. And then the last thing I'd mention is that in the UK, and this is really an important question to follow, as I mentioned, Vince Cable put out this consultation a few days ago, and he asked really a very big and important question, which is, what is corporate governance for? Not what is it, because we've been focusing on that for decades now, but what's it for? Who does it benefit? Does it benefit the family? How can it benefit, for instance, a family owner of a company? How can it benefit systemic risk? So there's a whole range of issues. How can we make sure that corporate governance focuses on long-term performance? All of those questions are now being raised, and those are exactly the right questions that we should have been looking at for a long time. Let me close with a few suggestions about how this all may affect the GCC area. And I think it affects it in two areas. One is as in respect of GCC investment funds, state sector funds, sovereign wealth funds, and others that are invested both in the region and elsewhere. I think what it means is that sovereign wealth funds and state sector funds, who used to be very passive, make big investments and then step back, I think now the way has been cleared for them to be much more engaged as owners. I don't think there's as much fear about the sovereign wealth funds. After all, the United States now is a sovereign wealth fund. The United States government now owns General Motors and owns banks across the nation. And of course, in the UK, there's a longer history of that. So I think there's an expectation, actually, that funds need to play a role, not as a political activist, but to play a responsible and prudent role as an owner of companies. There are a number of ways to make that happen, to step up that. One is centers of excellence, for instance, to help funds understand the rights that now exist for them, how to use disclosures that are out there, how to make trustees and directors of funds more aware of the rights that exist, I think is probably a useful thing. And again, maybe looking at the Australian market and how they set up this Responsible Investor Academy, there may be some ideas for GCC governments in that respect. The second thing, of course, is to look at corporate governance for companies in the region and what we can learn from the reforms that have occurred. I think there's, in some ways, less of a conflict now between the trends abroad and the trends in the GCC. It used to be, again, we need independent directors. And for many family-owned companies, that's a big problem. Now I think with a greater focus on competence and performance, there's a little bit more common ground. And I think GCC countries can do a lot. I've worked in the UAE, and I've found that there is a big demand for understanding more about the culture of what a board is and how it operates. So I think the work that Hawkamah is doing, for example, is just exactly right and the right time for this. Dr. Saidi and I were both in Shanghai in April for a conference on corporate governance. We heard a lot about corporate governance with Chinese characteristics, is how it was called. I think perhaps it's time to think about corporate governance with GCC characteristics. And part of that needs to involve working with directors, having peer exercises where directors can work together, understand from each other. And we need to perhaps think about having champions of corporate governance. Grant will know that there's a Latin American roundtable that the OECD supports, and they put out they pick some of the great companies in the region that have understood that corporate governance benefits families, especially in transition between generations, and they put together a book, the Company Circle book. That kind of thing, if we can pick out companies that are doing really well, that might be a very useful approach for this region as well. Thank you.
Thank you very much, Stephen. In fact, one of the things that we're working on right now is to come up with a book showing with a series of studies showing that in reforming corporate governance, state-owned enterprises, there are successes in the region, and it's important to take these successes and then to try and take them further. Just one question to you: the role of the chair of the board. What is the emerging consensus on that?
Well, this is, of course, a very controversial issue in the United States, but it's not really very controversial elsewhere in the world. So in the United States, it's much more typical to have a combined chair and CEO. And so in that country, there'll be a lot of debate about whether to change. I think elsewhere there's more of a consensus that the chairman plays an important role, particularly for the controlling shareholder, if there is one. You need to have a leader of a board. I think if there is no leader of a board, there's no proper accountability and no proper oversight. And that's why I think having a combined chairman CEO myself is a mistake. But I think for most companies and most investors, you want to have the chairman be the person responsible for interaction with the shareholders, to be the channel for either if it's lots of shareholders or the controlling shareholder, the channel between the shareholder and management of the company.
Good. Just a last point. It was acute embarrassment for me when I went through looking at the principles again and saw that we hadn't mentioned the role of the chairman of the board. I take full responsibility for that. The next time we revise it, that will be changed.
Well, to be fair, it was probably the U.S. delegates that blocked any change in that. So it wasn't your fault.
No comment. But Nick is indicating to me that we're out of time. I would like to have had questions from the audience, but I'm sure that we can continue that when we have coffee, and you can approach all the panelists here to take up points with them. So thank you very much, and thank you to the discussants.